begin our panel discussion today, I would like to thank several important people, in particular John Brayman, Janae Weaver, and Professor Sandler, who organized all the speakers today and are thus responsible for bringing all of us here today as well. It is important to note that straight allies like Mr. Brayman, Professor Sandler, as well as Ms. Weaver are essential to the success of any future gay rights movement. The goal of today's panel discussion is to figure out where do we go from here? How should we continue the fight for full equality? Our hope is that by learning from the individual experiences of key figures within the equality movement, that others in the community will not only be energized, but also inspired to push for greater equality for their families, their friends, and their fellow Iowans. Today's guests are Camilla Taylor, Janelle Reddig, and Brad Clark. Camilla Taylor is the senior staff attorney in Lambda Legal's Midwest Regional Office and was the architect of the couple's case in Barnum v. Reed. Lambda Legal is the oldest and largest national legal organization committed to achieving full recognition of the civil rights of lesbians, gay men, bisexuals, transgender people, and people with HIV. She will talk about placing Barnum in a national context and telling the story of how the lawsuit came to Iowa. Janelle Reddig is the supervisor of the Johnson County Board of Supervisors and a dedicated gay rights activist. Since coming to Johnson County nearly 2 decades ago, Janelle has been an active member of our community. She has served on commissions at the city, county, and state levels. She has worked for state and federal government, for nonprofits, owned a small business, and has volunteered for numerous local organizations. Supervisor Reddig will discuss how we arrived at this moment in time of GLBT civil rights and marriage equality in Iowa, and where we go from here. Brad Clark is campaign director for One Iowa, the state's largest nonprofit advocacy group advocating for LGBT individuals. Brad began his career working on LGBT youth issues in Iowa. As the executive director of Iowa Safe Schools, he led a coalition of education leaders and civil rights advocates to help pass a statewide safe schools law, protecting all students, including those that are LGBT, from bullying and harassment, in addition to a civil rights law to protect Iowans from discrimination in employment, housing, education, credit, and public accommodation based on sexual orientation and gender identity. Today, Mr. Clark will talk about 5 years from safe schools to civil rights legislation to the constitutional amendment and the changing political landscape.
Well, thank you very much for that extremely moving introduction, and also for illustrating why it is so very important to all of us that we continue to struggle for full equality, and why it is that so many people, including those who are here on the panel with me, and it's really my honor to be speaking with you here today. The reasons why you called us in and asked us to bring this lawsuit in the first place. So it is the importance of being able to share our commitment and to take care of each other that explains this case. And we couldn't be more thrilled to be here celebrating an anniversary. I'm remembering back to a year ago when we were gathering in Des Moines with the plaintiffs in the suit, and we were incredibly nervous, and none of us slept that night as we were both hopeful and fearful about what the outcome of the lawsuit could be. And to be here knowing that the plaintiff couples in the suit and so many others have gotten married and have shared their joy with friends and family members is just more thrilling than I can describe. I think this is a very significant case, not just for the joy that it has brought so many Iowans who've had the opportunity to get married in the last year, but also for the way that it has transformed the conversation nationally. And I'll explain a bit more what I mean by that. When we considered filing suit in Iowa, and this was as a result of the calls that we had fielded for so many years from so many couples, the landscape nationally looked very different. There were only 2 states at that time that were issuing marriage licenses to same-sex couples at the time that the Iowa Supreme Court decision came down. But when we actually were considering filing the lawsuit in the first place, there was no state in the country that permitted same-sex couples to marry. And around that time, we started receiving a lot of phone calls, especially from Janelle and Robin. And as anyone who knows Janelle knows, it is very difficult to say no to Janelle. But there were also other phone calls that we were getting from a wonderful family, Jen and Dawn Barbarowski here in Iowa City, who have 2 incredibly beautiful and strong little girls, McKinley and Brianna. And a number of other couples as well, of course, here in Iowa City. And all of these couples explained to us that they felt that this state was ready to understand the need for equality, that they would be respected by their neighbors, by their communities, and that their children would receive respect from their friends in school and from their friends' parents, and that this was the time. And Janelle and Robin, for example, would read aloud to me Iowa's state motto and explain to me Iowa's history of early leadership on many issues with respect to civil rights. And just to give you a few of my favorite examples, Iowa actually is the first state in the country to permit a woman to practice law, Arabella Mansfield, and that's one of my favorite examples. And this was in fact a few years earlier than the U.S. Supreme Court declared in a case that was brought by an Illinois woman that women had no place in the law, and there was no constitutional right implicated by the refusal of Illinois courts to permit her to be licensed as a lawyer. Iowa actually desegregated its schools by court order almost 100 years before Brown versus Board of Education, and Iowa was among the earliest states to eliminate its ban on interracial marriage. So there are many ways in which Iowa had taken early leadership on civil rights issues. Additionally, the Iowa courts had had a much broader concept of the state constitutional guarantees of liberty and equality than is true in the federal courts. And the court had made clear on a number of different occasions that the state constitutional guarantee, both of liberty and of equality, is greater in breadth and in substance than that is available in the federal courts. So these were, of course, very meaningful considerations for us as we considered whether to bring suit. Ultimately, the lawsuit involved 6 couples from around the state. One couple, of course, was Jen and Dawn Barbarowski here in Iowa City, but then there were also couples in Decorah and in Cedar Rapids, in Des Moines, in Council Bluffs, and in Sioux City. And all of these couples were incredibly brave. They essentially put their lives on hold for the duration of the lawsuit. They knew that they would receive a great deal of media attention. They were prepared to deal with that. They understood that they would basically be the ambassadors for the case for the duration of the lawsuit. And they could not have been stronger or braver or more wonderful people throughout the entire case, and we're tremendously proud to have been able to work with them. One of the things that they did that I think was one of the most courageous things that I have ever asked a plaintiff to do in a lawsuit was when we went to them and asked them to designate their own children as plaintiffs. The couples who had already finalized their adoptions didn't hesitate. We didn't ask the other couples who were foster parents to do so. And they agreed to designate their children as plaintiffs, which was something that we had not asked plaintiffs in any other marriage lawsuit to do, and this was the reason why. In Iowa, the defendant had articulated this argument. The defendant had argued that the purpose of marriage law is to protect the children of heterosexual couples who might be procreated accidentally or irresponsibly. And that the purpose of the marriage ban was to channel procreation into heterosexual families. So we wanted the defendant to have to answer, if the purpose of marriage law is to protect children, then why is it that you are saying that these children, the children of same-sex couples, are any less deserving of respect or protection? Surely the state of Iowa values these children just as much as it values any other children. And I think that that was a very important thing for us to do. And of course, it took a great deal of courage for the families to agree that their children would play such a central role, not just in the argument, but also in the discussion around the case. There was something else that we did that was a little bit different from what we had done in other marriage lawsuits, and that was to designate expert witnesses to testify and make a record in the trial court on a number of social science issues. Specifically, because the defendant had argued that it was important, that it was a valid state interest to channel procreation into different sex couples' families, we needed to make clear to the court that the child welfare social science is completely settled, that there's complete consensus among the scientists who study child developmental psychology and who study pediatrics, that the outcomes for children of same-sex couples are just as good as the outcomes for children of different sex couples, that there are no significant differences in these families. And this is true as of 30 years of research and numerous studies. So we chose the most highly respected child developmental psychologists and pediatricians and others from around the country who testified before the trial court. This was something also that hadn't been done since the very earliest days in Hawaii, that it was necessary in this lawsuit in part because of the arguments that were made by the defendant in the lawsuit. And I think that those two decisions were in part responsible for the very child-centered focus of the Iowa Supreme Court decision, which is a ringing statement, not just of equality for same-sex couples, but of the need to value all families equally. The decision itself, I think, as I said, had a transformative effect not just within Iowa, but outside of Iowa's borders. And if you look at just one measure of that, there are now 6 jurisdictions around the country that permit same-sex couples to marry, and there are others that will respect the marriages of same-sex couples that take place elsewhere. This was a unanimous decision issued by a bipartisan court. It was a decision in the heartland of the country. It was the first such decision. And I think all of those things were very important, in addition to the fact that the decision was written in a very plain-spoken way. It was written not just for lawyers, but for everybody. And it was a beautiful, beautiful work. So where to go from here? Well, of course, it's important not to be complacent. And so while it's been a wonderful year, when we've seen so much happiness among so many families, we still have a great deal of work to do because we need to make sure that we protect equality in civil marriage that we're currently enjoying. And litigation is only one part, one tiny piece of the movement in which we're engaged. And as we've learned in places like California and in Maine, if we don't remain vigilant in protecting equality, we can have it taken away from us. So as we think about where we go from here and moving forward, I think the work of Brad and of Janelle and of so many others takes on a special importance. And it's, of course, a great privilege for me to be up on the panel speaking with you. And as I was speaking earlier with Professor Kerber, there was a point in this lawsuit when, because of all of the amicus support we've received and all of the activism of individual Iowans who decided to speak out to their friends and neighbors and to go to house parties, to come to a rally, to email legislators, we felt that the weight of the case was really lifted off of our shoulders and carried forward by so many other people. We were honored to have the support before the Iowa Supreme Court of 150 different faith leaders in an amicus brief. We had the support of Iowa pediatricians, of historians, of law professors, including so many here. And that made a huge difference to the court's decision. But it's important for this broad coalition from so many different aspects of Iowa society to continue to work together to preserve what we have. So as grateful as we are, we look forward to working with you in the future as well. Thank you.
I'm going to set a broader history, and I think Brad's going to take care of more of the end of it, so I'll go next and put that I don't believe the lawsuit was decided in a vacuum, and I think you have to go back to our history, not Supreme Court rulings necessarily, although I think that is what Camilla talked about, but our entire history in GLBT civil rights. And so if you'll take a little journey with me and don't try to memorize all the dates, I can actually tell them to you later, but just put them in the right decade. In 1969 was the Stonewall riots in New York City. Okay. People were arrested for just dancing with their same-sex partners. And one night, a group of people, mainly led by drag queens and bull dykes, decided they'd had enough. And that created the Stonewall riots. A year later, the University of Iowa had a student organization formed called the UI Gay Lesbian Front. That was the first student organization recognized by a university anywhere in the country. And it occurred less than a year after or about a year after the Stonewall riots. In 1977, well, actually in 1976, these two young men, hippies, I can pass this around, Tracy Borgham and Ken Birch, went to the Polk County Recorder and asked to have a marriage license. This is June 9th, 1976. and they ended up on page 3A of the Des Moines Register. These two young hippies, 20 and 24, in 1976, asked to get a marriage license. We've been working on this a long, long time. But in 1977, Iowa City adds sexual orientation to its civil rights code, making us one of the first in the country to do so. Later, we introduced a civil rights bill in 1987, adding sexual orientation to the Civil Rights Code of Iowa, and it passed one chamber of the legislature, and it couldn't get through the other. If that would have happened, we would have been the first state in the country to have sexual orientation, but it didn't happen. The next year, it failed or 2 years later, it failed in the other chamber. It would take us 20 years to pass a civil rights bill. These things don't happen in a vacuum. In those 20 years, cities across the state started changing their human rights codes, their civil rights codes, and adding sexual orientation. In 1995, Iowa City added gender identity to its human rights code with a unanimous vote of the city council. I'm not sure they knew what they were doing, but on the floor, at the suggestion of a citizen, the Human Rights Commission had advanced creating sexual orientation, which we had had for 11 years, and adding gender identity as a subclass of sexual orientation. And a citizen came forward to the city council and said, you know, that's really not the way you should do it. Sexual orientation and gender identity have nothing to do with each other. If you're going to do this right, you should make them separate classes. And the city council changed it on the floor and made it 2 classes. That made us a rather radical or progressive, depending on your point of view, community. Then other cities continue to do it. By the time we got to passing the statewide civil rights ordinance in 2007, a lot of our major population of communities already had a civil rights ordinance with sexual orientation, including Johnson County. Johnson County was the first, and I think may remain the only, to ever have a human rights ordinance that adds sexual orientation and gender identity, because then we got a statewide ordinance. Johnson County's role in that was a good litmus test about why we should be adding both classes. I'm going to talk just for a minute about the history of how we get to the marriage lawsuit and what steps had to happen in the middle of this. In 2003, Canada started doing marriages, and Americans started going to Canada, including myself and my partner, Robin Butler, up there. Robin had breast cancer earlier, and we sat around and we thought, man, is this our only chance? I mean, we don't want one of us to die and to have been strangers in the eyes of any law whatsoever. And so we ultimately decided that we would go ahead and go to Toronto and get married. And it was a joyous and wonderful occasion until you came back across the border. When you went across the border, they ask you why you were there, and you tell them to get married, and you're all excited. And when you come back across, you realize that your marriage certificate really has no meaning coming back. Well, what happened was a newspaper here in our community refused to print our marriage announcement. We were going to have a reception here in town. We basically eloped. We went to Canada. We didn't tell anyone. Nobody was there. Some strangers from North Carolina had to be our witnesses. And people were very, very mad at us for doing this. And so we decided we needed to have a party. Well, we put our marriage announcements. You pay for this privilege if you're going to get a picture, you're going to have any details. And the Cedar Rapids Gazette refused to print it. They wanted to print it in unions and celebrations. And finally, Robin said to him, if a straight couple went to Toronto and got married and decided to come back and have a reception, where would you print that? Under marriages. She said, end of case. And the publisher said, I guess you're right. But that kind of started what I felt was a change in our lives. We had been fighting for the civil rights ordinance for a long time before that. But we decided at that point that marriage to us was, you know, this was our calling at this moment. And so I think on January 29th, 2004 was the first date I spoke to Camilla Taylor. My notes in my files, and we have files that will kill many trees, but I think it was January 29th, 2004 when we first spoke to Camilla, and I asked her if she had ever read the Iowa Constitution. And what she said eventually is, I have now read the Iowa Constitution, and it's absolutely amazing, and can we talk more? And simultaneously with this was a very serious challenge to amend the Iowa Constitution to ban marriage equality for basically ever. And so simultaneously with Lambda Legal coming into our lives as Iowans was a serious effort in Des Moines to ban marriage equality. And my notes here say that I sent out the first email about this on February 2nd, 2004 to about 50 friends. And it was just a little email saying, these legislators are about to do something really, really bad and you need to know about it. And that email started circulating all over the state. And with time, it led to this stack of emails that would go to thousands and thousands of Iowans who started talking to their legislators and saying, how dare you, how can you consider doing this? We, I think, along with the date of April 3rd, 2009, a date that we should remember is March 23rd, 2004. And that's the date that the Iowa Senate stood on the right side of equality, and they blocked the constitutional amendment, with all of the Democrats and 4 courageous Republicans led by Senator Mary Lundby from Marion, who has now passed away as cancer. And I think one of Mary's epitaphs should be, she stood on the side of civil rights before it was cool. She'd helped us with the Civil Rights Bill, and she, amongst anyone, deserves as much credit as we could possibly give her for blocking the constitutional amendment. And that set the stage for everything, because Camilla had told me, we don't want to come to Iowa if we're going to make it worse for you. And if there's any way that we could cause a constitutional amendment to happen by filing a lawsuit, we don't want to do that. And so blocking that constitutional amendment and giving senators courage to stand on the right side, and led by Senator Gronstal, the Democratic leader of the Senate, that led us to the point where Camilla makes her first appearance here in Iowa, on my notes say on May 17th, 2004, when she first comes here to speak at the University of Iowa for a forum called Marriage Does Matter. And so Camilla has been here now with us for 6 years. And if you see my Facebook page today, you'll note that I say that many same-sex couples across the country should be naming their children Camilla. And I think that's true. I think when you talk about people who believed in us, who were willing to come to what people considered a conservative state, not red or blue, but both at the same time, Camilla's belief in coming here that we could block a constitutional amendment, that we could get a civil rights bill, and that we could win marriage equality, and then we could hold off on a constitutional amendment even after that, that led to everything. And from my perspective, I think that this has reminded Iowans that we have stood on the right side of civil rights so many times. We have so many firsts, whether it's here at the University of Iowa or at the Supreme Court. And this is just one more story in our long history. And so now our job is to defend it, and I think Brad might be willing to talk about that. So I'm happy to answer any questions.
Well, thank you for having me. It's a pleasure to share this panel with these 2 wonderful women. For me, this anniversary is really personal. You know, growing up a gay kid in small town Iowa, I never ever thought that this day would be here, and it's been really an incredible year. And just to look back, 10 to 15 years ago, we were looking at, Matt Shepard had just been killed. Ellen DeGeneres had lost her television show, and after coming out, and we're today celebrating the first year anniversary of marriage in the center of our country. It's quite a momentous occasion. But I think a lot of the groundwork has been going on for several decades, people coming out, sharing their stories. And really what we've seen in the last 5 years in Iowa is that what some people describe as that tipping point, where we put forward an incredible case in the courts. We saw a political landscape in our state really changing. We had a Democratic majority, a fair-minded majority coming in to power in 2007 after the 2006 elections. And really that's when we saw all of this work over several years coming to fruition. We'd been working for a number of years to pass a safe schools bill to protect all kids in schools for many decades, to pass a civil rights bill. And some of the spearheading of that went from the Iowa Civil Rights Commission. After Governor Vilsack came in to office, he appointed a lot of fair-minded folks to the State Civil Rights Commission who really wanted to start addressing sexual orientation and gender identity, having conversations around the state outside of places like Des Moines or Johnson County, and going to places like where I'm from, Pella, where these conversations just take place in a little bit different fashion. And they amassed a very healthy coalition of civil rights activists, educators, business leaders, labor leaders, all sorts of folks that really wanted to start talking about this. And so in 2007, we saw the passage of the Safe Schools Bill and the Civil Rights Act, and signed by Governor Culver, in both chambers, led by Senator Gronstal, Speaker Murphy, and then Governor Culver, really strong advocates for fairness and equality over the last many years. And as Janelle said, in 2004, we saw that blockage of the constitutional amendment. In the previous bills that I talked about too, the Safe Schools Bill and the Civil Rights Bill, the incredible thing is that both of those bills and the constitutional amendment was blocked in a bipartisan fashion. And just that change in political climate over the last few years is the Democratic caucus has gotten, it truly is a big tent party now. Versus Republican caucus that has really narrowed the scope of what they're willing to engage with. The Civil Rights Bill passed with probably 10 Republican legislators coming on board. The Safe Schools, more than that. And today it would be very hard to get both of those pieces of legislation through, given the current climate in Des Moines. And so, we need to keep up these efforts. As many of you know, just this last week, the legislative session closed. And that really puts the marriage equality ruling further and further into the future. As it stands today, the earliest that a constitutional amendment could be voted on in the state is 2013, if given a special election, if the legislature elected to have a special election on the amendment. As many of you know, a constitutional amendment has to go through the legislature, 2 consecutive general assemblies. Each of those general assemblies are 2 years long, so it would have to go through in the 2011 session, 2011-2012 General Assembly, and then again in the 2013-14 General Assembly in order to be voted on by the people. But as we've seen public opinion changing quite dramatically over the last several years, we need to keep up that vigilance, as both of my co-presenters have talked about. We need to keep changing public opinion on this issue. And we have seen it. And you look at any piece of research or evidence points to the fact that the only thing that's actually changing people's minds is once they get to know someone that's gay, lesbian, bisexual, or transgender. And so the importance of coming out and sharing your stories is very, very important moving forward. The other thing that we've really seen over the last several years is a great effort to build a very strong coalition. It's not just LGBT folks that are fighting for these rights. We have a coalition now that represents over 100 organizations throughout the state. Put together, all of those organizations represent over 200,000 Iowans. We're talking about AFSCME, the Iowa Federation of Labor, business leaders, religious leaders, all around the state. And really that's what is also changing public opinion, when it's not just a small group of far left-leaning people. We're talking about people from all sides of this issue putting forward a fair-minded agenda. The other piece of evidence that we're looking at, some of you might remember House District 90. Shortly after the court decision, there was a special election in Fairfield, where just south of here, where we saw a group called the National Organization for Marriage invest close to $100,000 in that special election, trying to take away one of our legislative seats by putting radio and television ads up about marriage. And their message fell flat. We won that election by over 100 votes. I know that that's a very small margin, but many of these legislative seats, that one in particular, has been won by less than 100 votes. Some of them won less, 20 to 30 to 40 votes. So we felt very good about that election, especially after a court ruling in a very conservative part of the state. And I think we're going to see more of that in the year to come. One Republican candidate for governor has promised to make this election about marriage, and he has so far throughout his campaign. And I really have to believe that that message is falling flat on voters. As people continue to lose their jobs and the economy is in the state that it's at, I don't think people really want to be concentrating on taking away folks' right. But more important than that, I think we had many years where far-right folks were feeding voters this kind of hateful, fear-based message. And I think people are really over that. And our candidates are running on a very pro-equality, anti-discrimination agenda. And I think that does resonate with voters. You look at a pro-equality candidate today will win over an anti-equality candidate. And I think that's just going to continue to change. As it stands today, we have a fair-minded majority in both the Iowa House and the Iowa Senate. Significant number of those seats are up in November. All 100 of the Iowa House seats are up. 25 of the Senate seats are up. Of those 25 seats in the Senate that are up, 19 are Democrats. And so we have our work cut out for us to protect this majority, and we're very committed to doing that. The other piece that is out there is obviously, as many of you know, is a constitutional convention, which both our organization, One Iowa, and the opposition, the Iowa Family Policy Center, and folks all across the board on the left and the right and in the middle have all come out against a constitutional convention, not wanting to open up the Constitution to debate. So, we don't see this particular issue, this ruling being done today or tomorrow or really anytime soon, but we have a pause for celebration hopefully over the next week, and I just appreciate being here today.
So we'll open up for questions if anyone has.
I have a question for Ms. Taylor. Ever since the Barnum decision, I've just been curious, thinking more about the defendant's side and what it would be like to be on that side and have to defend the I guess it was the county's policy that was at issue. Did you get any sense that there was less than complete enthusiasm on the other side for defending this law, and how does that play out in a litigation situation like the one you were in?
Well, I think that the county, the attorney who litigated the case for the county, put up a genuinely best effort defense on behalf of the county, as he was obliged to do. He also was assisted by the shadow law firm, really, who did much of the work of litigating the case for the county, which was the Alliance Defense Fund, which is an organization with a budget of something like $30 million. It's based in Scottsdale, Arizona, and its primary mission is to diminish the civil rights of lesbian, gay, bisexual, and transgender persons. So the Alliance Defense Fund, for example, found all of the expert witnesses, purported experts, that were designated by the defendant on the other side. And these were hobbyists and ideologues who wanted to testify about child welfare, social science, but who, with only one exception, had not actually read any of the studies and were testifying from a very personal position and religious position for the most part. Yet nevertheless, they were very prominent people, but they were professors of religion and and so on. So the county did work with the Alliance Defense Fund to prepare these individuals for their depositions and did a lot of the drafting with them, and it was a very vigorous defense that was put up by the county. That's not to say that the particular elected official, the county recorder whom we sued, was himself in favor of excluding gay and lesbian people from marriage, but it was the obligation of the county to put up that defense. It's interesting to see how the defendants in different marriage lawsuits have chosen to defend cases, and not every defendant has chosen to use the arguments that were made by the Alliance Defense Fund, which were really, I think, the most extreme and far out there arguments, and the defendant in this case chose to make the case about children. That had not been the case in many of the other lawsuits around the country, but defending that position a bit for them, I think in part they chose that argument because it had been accepted by the high courts of New York and Washington. And so to a certain extent they may have felt that, that they needed to make those arguments because those were the arguments that had held sway elsewhere. And the reason why the courts in New York and Washington had reached out for these child-focused arguments in upholding marriage bans was because they had been made by amicus briefs, by friend of the court briefs that had been submitted by organizations like the Alliance Defense Fund.
Sure, go ahead.
Hi, one question for Mr. Clark. You've talked about supporting Congress and that. What's being done to support the greatest justices for the retention bill? And what could we do to help?
I think it's likely that movement's going to be led by legal organizations to support justices, and I believe 3 of them are on the ballot for retention. And I think what you all can do, obviously, it's going to take money, so contributing to whatever system is set up to support their retention. Also, just talking to your friends and neighbors and those in the legal community about Iowa's commitment to a clean judicial system. You know, Iowa has a very long history of retention. I don't fully understand it. I'm not an expert at that, but you know, I think it's well respected around the country, and the need to not undermine that judicial system and just talking among legal organizations will be very critical.
There's also one of the Supreme Court justices is married to a state senator. And there's a backhanded way to go after him in this ruling by trying to knock her off in her Senate seat. And this could be the most competitive or Senate seat in the state, and that's Stacey Apple, which is district south of Des Moines. And her husband was one of the people who voted unanimously in the Varnum case, and she's being targeted in part. In the recent public opinion surveys that have been done, she's in serious trouble there. And I think they're going to dump a ton of money to try to knock her off for a lot of reasons, but they are listing this as one of them. Her support for, and her family's support for these type of issues. So it happens in a lot of different directions. This could be a dialogue. John?
I wanted to ask Camilla a follow-up question. As you're thinking about possible avenues of defense tactic here, in what ways did the Iowa Constitution serve to kind of box in the framework of the argument in ways that are unique here and that might allow a much more vigorous defense in other places? I mean,
I guess answering the question a bit more generally, there are a number of ways in which the Iowa Constitution defined the parameters of the case and is unique. The Iowa Constitution's guarantee of equality has been held on numerous occasions to be broader than the federal guarantee of equality. And there was a case in February of 2004, the famous Racy 2 case, in which the Iowa Supreme Court struck down a taxation measure based on rational basis analysis, which is the lowest level of review applied to equality claims under the state or federal constitution. And the Iowa court found that this taxation statute violated the Iowa Constitution's equality guarantee and the federal Constitution's equality guarantee. And this case went up to the U.S. Supreme Court. The U.S. Supreme Court said, actually, there's nothing here that violates the federal constitutional guarantee of equality. It's really low level of review. It's practically nothing at all. And remanded the case back down for the Iowa Supreme Court to act in accordance with its decision. And the Iowa Supreme Court then ruled, well, it nevertheless violates our own equality guarantee, which is broader than the federal, and did not, and continued to find that the law was unconstitutional. So there are very striking examples of the Iowa court's independence in charting its own vision of equality over many, many years, and in contexts far afield from civil rights. So we had those cases to work with, which were very important. In the liberty context, there had been another example in which the Iowa court had considered a case that was almost identical in facts to a case that recently had been decided by the U.S. Supreme Court. And the U.S. Supreme Court, in Michael H. versus Gerald D., if you're interested, had determined that the litigant in that case had no liberty interest that was infringed by the law at issue. It was a law governing whether putative fathers can make a claim for paternity with respect to a child born to a married couple. And the Iowa court, considering identical facts, said, actually, this individual does have a liberty interest that's implicated by this case, and he should be allowed to put forward his case, to make out his case, because the Iowa Constitution's guarantee of liberty demands it. And in doing so, it actually made some very beautiful statements about the importance of valuing non-traditional families and of understanding that parent-child relationships can arise even in contexts that have not traditionally been embraced. So those were the sorts of cases that really became the focus of the argument. Now, why did the defendant choose to defend the marriage ban on the grounds that the defendant did? To a certain extent, and those arguments had been raised before, but usually by amicus briefs. And the response from our side had always been, well, we know that the marriage ban doesn't serve the interests of children. The marriage ban isn't to channel procreation into certain households, because we know that people who have no interest in having children can get married. People who are incapable of having children can get married. We know, in fact, that people who are presumed bad parents, either because they have been adjudicated guilty of child molestation or of some other violent offense, or because they're in jail, or because they have been repeatedly found to be deadbeats on child support matters. We know all of them can get married, and in fact, they have a fundamental right to marry. So we know that the law does not serve the purpose of benefiting children, this marriage ban. And that had been our argument in other cases, and it's a very persuasive argument. But given the fact that the defendant had chosen to make children really the focus of the argument, we felt we had to go further and say, okay, well, you claim that the law benefits children in these ways. So answer these children of same-sex couples, in fact, Jameson, McKinley, Brianna. Answer them why they cannot share those benefits that you say are so important. What is it about these children that makes them any less deserving? So it was a decision that we hadn't done before, in part because those arguments hadn't been so central. We'd relied exclusively on the legal arguments in the past.
Were you surprised by the result, or by the unanimity of the result? What were your fears about?
Camilla doesn't want to hear this, but I knew we were going to win the first day I read the Constitution. I didn't grow up in Iowa. I didn't read our Constitution. I had no reason to read the Constitution until they decided they actually wanted to change the Constitution. And when I read our Constitution, it's law's uniform that I found to be one of the most compelling arguments. We have equal protection and we have law's uniform. A lot of states don't have this, and Camilla can tell me the history. of how many states have this, but it makes our Constitution rather unique. And so I knew we were going to win the minute I read our Constitution. Now, it would take Camilla 5 years to prove that, and I used to call her at 10 o'clock on a Saturday night to leave her a message, and she'd actually answer the phone. And this is prior to her having children of her own. And I would say, go home. And she said, well, you're still working on the issue, so why should I have to go home? But I honestly think that this was predetermined by the way our Constitution was written. And all of you who are in law school and all of you who are professors and lawyers can argue with me all you want, but I just think that equal protection and laws uniform made this a predetermined outcome. For it to be unanimous is a different matter. I mean, you know, I think that there's always someone who will play politics or their own personal religious background, and I found it being unanimous to be the most interesting and surprising thing for me. Now you can give the real legal answer here.
Well, there's another person too. I mean, in addition to Brad and Janelle, to whom we owe so much, and including the wonderful decision and its unanimity, and that's of course Dennis Johnson, who's our co-counsel and most incredible lawyer who argued the case. And he opened his oral argument before the Iowa Supreme Court by quoting the Constitution. Very simple way to do it. And in doing so, he referred back to the earliest debates when the Constitution was written, the Constitution of the state of Iowa. And Iowa's equality guarantee actually predates the federal Equal Protection Clause. And you can find participants in the Constitutional Convention, delegates, who actually said, on the record, we want our equality guarantee to be as broad as it can possibly be. And so it really is, I think, in some ways, predestined by those wise people who came before us, in addition to having been helped along by people like Dennis Johnson, who also closed his argument with a very personal demand that the court act in a way that would respect fairness. And he talked about his own marriage to his wife and how much it meant to him, and how hurt he would be if the state were to say that you can't get married, but other people can, or we're not going to respect your marriage anymore, but we are going to respect other people's marriages. And I think that very personal discussion from someone who had such tremendous respect, a former Solicitor General of Iowa, was a very unusual way for a lawyer to end an oral argument, and extremely compelling. And it was hard for all of us not to have tears in our eyes when we listened to it.
His speech was quite compelling. I was interested in the way the Chief Justice handled the publicity and her introduction and telling people about the case and setting the stage. How was it handled within other states? And do you think it's had any effect in people's acceptance of the decision? It's the first time we've seen anyone really explain what was at stake and ask for courtesy. And that's something we don't generally see in courts.
Well, I think in many ways it's a reflection of Iowa culture and civility. And we've certainly encountered in our conversations with people throughout the state this understanding that we're all human beings, that we speak to each other with respect. And it's a level of discourse and discussion that's been very helpful, and that I think really speaks volumes about what the culture of Iowa really is. There have been other states in which the high courts have published the amicus briefs in the same way and made them available in links on the website, and certainly California's high court recognized the degree to which lay people, non-lawyers, would take an interest in the case. But to have it explained in that way by the chief before the oral argument, so that everyone could understand who was watching what the stakes were and what the nature of the arguments were, that was unique. And I think also the decision itself, because it is so very plain-spoken, it's clearly anticipated to be something that would be read not just by lawyers, but by everybody. And it addressed arguments that we hadn't made, that were not actually legal arguments, but were concerns that everyone knew were being discussed in the more open forum of the public. That I think was very useful in helping to put the decision in context and make it more easily understood, and it was unique.
And I think as well it went to the impact that Barnum had on the rest of the country, and that, in addition to it being a unanimous victory in the center of our country, that alone has had a huge impact, I think, in terms of public opinion on this issue in general. I don't know what the right word is, but on Twitter, right after the decision we had some sort of trend where Iowa was constantly coming up, and people just very shocked and surprised that this could happen in Iowa. But I think to Janelle's point, I don't know that Iowans themselves were that shocked or surprised, but everyone around the country was. But also I think some of the points that Camilla was making, specifically the one about the court talking about the difference between civil and religious marriage, and really politically that's how we've seen politicians talk about that since then. Both in Iowa, Governor Culver really framed his whole message around that, and it's really resonated with voters, and that's really at the heart of a lot of this discussion. This is not going to have an impact on houses of worship. And you've seen politicians outside the state really model their language after the governor and after the court.
Go ahead.
I just wanted to thank you all for the tremendous efforts to make me continue to be proud.
Well, thank you. I think that blocking the constitutional amendment took thousands of us to do. And it's every contact you've ever had with anybody who's in elected office that leads us to this moment in time. So although I believe you should all name your children Camilla, I think the Iowans made this happen, and there are thousands of us, and it's hard to pinpoint any particular moment or time other than naming your children Camilla. And I know we're coming to a close, and I'd just like to say something that it's not over, and it's not over in so many ways. We continue to fight racial equality, and we haven't won that either. And so, some of you know that I was in an election earlier this year, and in a special election, and they said, we don't want a rainbow agenda in the courthouse. And at a debate, we had some people in the audience were chanting, "You are a sinner, you are a sinner." At which point my friend Elsie here nearly got into a fist fight after the forum, defending my honor. But I won. Nobody's been beaten in Iowa over this issue, period. I mean, there's not been a race that was decided on this issue. Actually, the reverse. There was a primary in a Republican Party that was decided because they thought the person had spent too much time gay bashing, actually. That might change this year, but I don't think it will be the marriage equality that will change any races. There's a lot more going on in Iowa. There's the economy, and there's jobs, and there's flood recovery, and there's climate change, and there's, we're not funding education, and we still don't have health care figured out. And so if someone's defeated this year, do not let anybody say that it was because of this issue, because this is just not going to be the case. But we do have to keep one chamber or the other fair-minded this election cycle. We need another 2 years to change public opinion. I don't want to vote on this in the summer of 2013. I think we could win, but I think it would be miserable. And I've got a lot better things to do with my time. And so if we do get to that point, you all might as well take your summer off because you'll be helping. But we could use 2 more years. So whether you're Democrat, Republican, Green, Libertarian, Socialist, whatever, we need one chamber to be fair-minded so that we can put this off another 2 years. And so that's my closing. Thank you for having me.
Hello, this is Elsie Vega with Neighbors and Friends on Channel 4, and I'm here with Brad Byron, who set up a forum here with the Outlaws. Would you tell us about the Outlaws?
Sure. So the Outlaws is the College of Law at the University of Iowa's LGBT group, and the College of Law is very proud to host us, and they have been kind enough to sponsor our group. And Iowa stands out as this amazing state where we have equal rights, and there are very, very few law schools that say that they are in a state where their students have equal rights. And so we worked hard to get everyone here, and people have been so generous, so supportive of everyone, and it is an honor to be called an Iowan now. I'm from New York, and New York, the progressive state, I can't go back home and be guaranteed the same rights. And so Iowa seems like the place for me here. And so I'm happy to host wonderful people like yourself here, and hopefully we get to have more wonderful conferences like this in the near future. Thank you.
Well, thank you. It's been a very interesting conference. Let the public know the work that has gone on, the work that will continue.
Yep.
Yeah.
It's an amazing event.
Yeah.
Wonderful. Thank you.
Thank you.
You know, today's just a really wonderful celebration, and you know, we've had a wonderful year. It's nice to take a little bit of a rest and celebrate.
And you're having, there's a dinner tomorrow in Des Moines?
Yep, there's a gala dinner tomorrow. We're hoping for about 300 people there, and it should be a very good time. We're honoring Senator Gronstal and Speaker Murphy, and then the 6 courageous couples.
So that will be a gathering together of the people, as you said, so courageous and so giving of their time.
Yeah. Thank you.
And your name, please?
Robin Butler.
Okay, and you're here with Janelle, of course.
I am here with my wife, Janelle, there, who was one of the presenters today. And it's been a long journey to get here today.
And you both have given a lot of time to this.
So, well, you know, it's interesting when we were going over our notes last night is how fast things happened. When in February of 2004, when it became apparent that there was going to be an attempt to amend the Constitution of Iowa, it was only 3 weeks later then we gather at the recorder's office to ask for marriage licenses. So, and I don't know if you know about that event. It was in February 27th of 2004 that we kind of called for people to come down and ask the county recorder for a marriage license, knowing all well that we would be denied, as our county recorder is Kim Painter, a good friend. But we wanted to make a statement that we are denied marriage licenses. If you had asked me 2 weeks ago how much time in between when the constitutional amendment was proposed and when we went to the recorder, I would have said like a year, but it was only 3 weeks. And so it's been interesting to kind of reflect back on the chronology of things that happened, but it was amazing how fast it all happened and how many people just instantly came together to fight that constitutional amendment, and then just to keep up the regular everyday lives so that we can be to a point where it's no big deal.
Thank you. As the panel said this afternoon, Iowans know the difference between fairness and non-fairness.
Yes, I believe that. We've given a lot of interviews over time, especially back when in about 2004, and that was one of the things we always emphasized, that we had faith in the people of Iowa, and that holds true today as well. So, thank you, Elsie. Okay.